Yes.
See, from daily gossip, serial number 35, MN number 391 of 17.
This was the case he was mentioning.
Yeah, this was the case he was mentioning. He was afraid of not mentioning that.
On the request of Mr. Jain Kumar Pandey, learned advocate, this case is adjourned for 1 week.
I told him that you mentioned clearly that what person refer you are right. Don't take the file missing and all those things.
Serial number 36, MN number 469 of 17. Mr. Ramchandra Sahu.
So, what is our student?
Miscellaneous
Someone is the respondent. Lawyer. For enhancement.
for him. इसमें फ्यूचर प्रोस्पेक्ट्स नहीं दिया गया इनकम विद द स्लैब का
Your appeal is only limited to future prospect.
नो also income.
Income, yes, let us see what is the income. What is your claim in respect of income?
20,000 per month. Page 19 also. Issue of income has been decided. Page 19.
Diploma in civil engineering. Service. The tribunal has considered your income to be. The
10,000.
tribunal has considered
10,000.
your income to be
10,000 rupees per year.
12,000.
10,000.
In light of the judgment of the Honorable Supreme Court in this similar issue, there is one judgment. There is one judgment. The student of yes. There is a judgment of the Supreme Court. You are arguing, you are making out your case on what basis?
Let's say, Digit was not doing diploma in civil
This
engineering.
is doing diploma, yes. So she was unemployed.
She was unemployed.
So he was unemployed, so why not 3,000 rupees per month per month notional income?
इसमें एक जजमेंट हम साइट किए थे लोअर कोर्ट में 2011 ACJ 702 इसमें 12,000 पर मंथ ये इंक्रीम ऑर्डर है ये मेंशन रेफर किया
What was mentioned? Just see, Mrs. Paul, how the advocacy is, quality of the advocacy and everything has gone down. As if everyone is arguing a bail application. No citation. The case is claiming that he is a student of BTech or something. So he is admittedly unemployed, so the income should be taken as 12,000 or 15,000.
That is not.
He is raising the principle. Where is that book?
Yes.
Where is that your citation? It says that we have cited a judgment which is there in the imperial law. Is this a way? Problem is, Mrs. Paul, you are the first lawyer when this bench was.
I am not the first, but simultaneously, I am Indra Chaudhary. Whatever you speak. Yes, yeah.
See,
That has been my day to day. We are
Day to day
very
it's-
sorry to say. And that is the reason for each of the cases.
No, the reason for this, you know why? 60%, rather 70% of the litigation in this court filing
Yes.
is only bail.
Yes.
This is the whole problem.
And that is also
Bail,
contributing to
there
accident.
is no law involved in bail.
Yes. That is much more easy and quick disposal than
This is not necessary of citation in bail application. There is no necessity of any drafting in bail application.
Yes.
We judges are some judges are lenient.
Really, advocacy is the subject, in that subject, in all that subject. We want to be interested for that. That is the dignity of the profession.
Now, if you are coming up with a principle, you back yourself up with the judgments. That is the easiest thing, time लीजिए, पढ़ेंगे नहीं, and not utilize the time when
टाइम लेके उस जजमेंट को पढ़ने
the last evening.
जजमेंट ले लीजिएगा। आशुतोष आनंद को भी है, रिसेंट जजमेंट हुआ है उसमें, ये वो रिसेंट जजमेंट है उसमें ऑनरेबल जस्टिस केपी देव का था, वेंट टू द सुप्रीम कोर्ट, द मैटर वाज रिमांडेड, नाम याद नहीं पड़ रहा है।
There are 2 or 3 judgments in last 4 years.
Yes.
Which says
आप टाइम ले लीजिए ना।
capacity to earn. If he is a good student, that has to be taken into consideration, and most probably in one case he was 50,000 was per annum was considered.
Something like that. In the case which was from our own High Court, that was the Honorable Justice K.P. Dev took a view that
You take the name of it.
oh yes, that the coordinate bench has taken a view that he cannot earn that much of money because he was not from that college or something like that. So therefore, the amount was reduced or perhaps reduced a bit.
But it was substantial.
It was substantial.
It was not a notional.
No, it's not
considering
notional.
planning. See,
But
his point is, since he was studying in an engineering college, the 5th semester, he has a capacity to earn, and that notional income, concept of notional income
will not
be
apply.
and it should be 12,000 or 15,000. He says I.
But the whole difficulty with utmost humility, taking everything upon myself. Taking everything upon myself, there is no consistency.
No,
There is no consistency.
He has produced a judgment.
Taking everything upon me.
Showing 12,000, right? Even he is not equipped with that judgment also which he has produced before the court. He doesn't have the time to take.
आप पास ओवर लीजिए, जजमेंट लेकर के कोर्ट चलिए लाइब्रेरी
It is good. It is very good in one sense that the proceeding of this court is live streamed. Let people understand.
आप
Let people
पास
understand.
ओवर
Yes,
लीजिए
each and
कोर्ट
every
से।
day we have to learn.
As a you and like the cases are being kept pending. See, this is one of the
But
reasons. It could have been decided just now.
Just
But on my 15 cases,
I have also called for the LCR also.
and at least the decision which has been cited, that should
my
be.
15 to 20 cases are listed every day. Even for the orders cases, I am ready with the facts, everything with judgment and all those things.
You were an advocate of
Old,
Ranchi bench of Patna High.
old school,
You were an advocate of Ranchi bench of Patna High.
old school.
You are
Old
not a
school.
lawyer of 2010 of Jharkhand. I'm sorry to say this.
One of the, I was
Let
appearing.
me be on record.
I was appearing.
I think there is no dispute at all.
Your Lordship, I was appearing in one case before the Honorable Judge in this courtroom itself. I was not read. I have not read the matter. The moment my senior कैसा डांटे थे तुमको पढ़े नहीं थे ना? Tell him, I said to my senior, ask him to read.
Very question for the next week.
पास वाली की जजमेंट लेके आओ तो तुरंत हो जाएगा। हम हेल्प कर देंगे, जाओ लेके आओ।
Cannot. It cannot. He has to search the latest 2 or 3 judgments on this issue.
Okay.
Need some homework. As a lawyer, if you want to excel, you have to do homework. And I'm sorry to say, cost of repetition I'm saying, this bail is destroying the lawyer's service.
can be improved if they want.
खाली वेट करके कोई कुछ नहीं बन सकता है। कुछ पैसा कमा लीजिएगा लेकिन वकील नहीं बन सकता। खाली वेट, खाली वेट करना है। इस सब केस लीजिए ही मत, बोल दीजिए यहाँ से नहीं, जब दूसरा किसी को दे दीजिए, हम खाली वेट करें।
ऐसा बोलने के लिए भी हिम्मत चाहिए that it is not possible by me that I left it.
60%, more than 60% of the filing in the last 2 years is bail in this High Court. 60 to 65%. I have the figures with me.
And that is the experience. But we have that experience in that side also. Each and every case will be argued so many times, but final judgment is not there. And 2 years to let it be listed before the court.
Yes.
That is the situation we are facing.
Next. What week? Next week. Maybe next week.
Serial number 37, MN number 593 or 17. This is still a.
I understand the case which are very complicated, it may take time. So this is simply case he is coming up for. After this Pranay Shetty judgment, I don't think so there is much complication in motor vehicle cases. It's a straight jacket formula now.
So far, the quantum is concerned.
Yes, quantum is concerned. For enhancement.
Enhancement.
For enhancement. Yes, Mr. Black.
Yes, my lord, this is for enhancement.
Yes.
My lord, the deceased was a medical representative. His monthly income was 27,000 and odd, but my lord, income assessed as rupees 10,000 and odd.
Where is this slip facing?
Yes, my lord. And my lord, no future prospect has been given. He was an unmarried. My lord, the claimants are father and mother, parents. My lord, compensation towards conventional heads, only 15,000 has been awarded. My lord, now Pranay Shetty said it should be 70,000.
Show me the money.
Yes, my lord. Kindly have a look to the running page. 15.
Exhibit.
Exhibit, yes, my lord. Exhibit 2. Exhibit 2 is the my lord payslip.
27,948.
Yes, my lord, the first my lord may go through the award, my lord, running page 15.
Why basic salary twice?
Yes, my lord, this salary slip is also not very
See, the
clear.
basic salary 2562 and then 7883.
Yes, my lord,
Why in a particular month?
my lord,
there
that has been discussed in my lord, paragraph 9 of the impugned award.
You have challenged that award, you satisfied me. This award. Why?
Paragraph 9. Running page 15, 15.
Gross salary 9.
It is conclusively proved. Have your lordship got it, my lord? Paragraph 9.
Just a minute. Exhibit 2. Exhibit 2, it says your gross salary is 10,005.
Exhibit,
He was a medical representative,
yes, my lord.
not a trainee.
No.
Then 10,500.
No.
Yes, you see Annexure 2. Exhibit 2. Exhibit 2 is an annexure to the confirmation letter. As a trainee, you would get 9,500. Okay. And 10,500 rise in the gross salary is 1,000. So 10,500 is your gross salary.
My lord, in the impugned award, paragraph 9 first.
9, yes, paragraph 9.
Yes, my lord. Here, my lord, the exhibit 2 is something different. Paragraph 9. It is conclusively proved.
Read.
Yes, well, it is conclusively proved on the basis of original certificate brought on record, as well as on the basis of post-mortem report that the deceased was aged about 28 years at the time of accident. It is also proved
Date of
that
accident.
28 years. Date of accident is, my lord, 27th of July 2012. (28 years at the time of accident). It is also proved that He was graduate in biotechnology and working as medical representative with Torrent Pharmaceuticals Limited. He died in motor road accident in the month of July 2012. System generated salary slip for the month of June 2012 is on record as Exhibit 2. Although the total earning for the month of June 2012 shown as rupees 27,948, but in the pay slip, basic salary, HRA and interim bonus shown to be given twice. But PW3 during cross examination specifically stated, PW3 was his co-worker, colleague, his colleague. PW3 during cross examination specifically stated that the basic salary to the tune of 2562 and HRA rupees 7681 is not part of the salary for the month of June 2012. Apart from above, I also noticed that several other benefits such as LTA, medical, travel, conveyance, internet, postage and courier expenses, stationery expenses also given to him. Now question is to be decided by this court whether this allowance payable to the deceased should be taken into consideration for the purpose of computing amount of compensation or not. It is established law that dearness allowance and house rent allowance are paid for the benefit of family members and not for the employee alone. Other elements such as traveling allowance, conveyance, internet allowance, postage and stationery cost should not be added to this monthly income because these are not contribution to the family. These allowances could not be considered as voluntary contribution by the deceased for the welfare of his family like GPF, LIC premium, etc. Thus, these allowances were exclusively attached with the service and for the benefit of the deceased alone. Therefore, I am taking into consideration for the purpose of computing the amount of contribution only basic salary, HRA and city compensatory allowance. But in the Exhibit 2, that is the payslip for the month of June 2012, there are other components. And now the Honorable Supreme Court has said, the gross salary with the
That is, Prunesh Shetty, gross salary means salary less
minus
PF.
income tax.
Oh, sorry, income tax.
Yes.
No, my question is something else. You are relying upon this exhibits 2. There are 2 exhibits. One is 27,940.
Yes, my lord.
So
This is
now tell me
payslip
how
for the
this,
month of June.
just tell me month. This 27,948.
Yes.
Are you
Twice.
claiming 27,948 to be salary?
Yes.
Then why there is 2 basic salaries?
Yes, my lord. There is some.
Why there is 2 HRs?
I have also asked my client, my lord, why? Because they are the parents of the deceased. They are the parents of the deceased.
And first of all, this
Same.
256, add this 2562 plus 7883, how much it comes to?
2562 has not been taken into consideration, my lord. Only, I am also not on that. 7083, that has been taken in as my lord basic salary. Then my lord 2125 has been taken as HRA, and my lord city compensatory allowance has been taken as 1000. My other components like my lord conveyance, then my lord medical, LTA, these things have not been considered. And my lord further, my lord, these deductions has also been my lord made. PF contribution, right hand side my lord deduction.
That is deducted from 27,000.
That should also be included in the my lord gross salary.
No, that is
Yes, my lord,
PF, PSI.
PF, PSI, these contributions.
So that is there in this exhibit to the other document chart. Annexure to the confirmation letter.
These are my
That
lord.
is annexure to the confirmation letter which you have annexed as exhibit to another. The total gross monthly salary is 10,500.
That was most probably dated my lord
There is no
16th of,
date.
yes my lord, 16th of November 2010, left hand side top my lord.
Which one?
My lord,
No, no. 15th of November 2000.
10.
When is when is your confirmation letter? When were you confirmed? Let's see.
My lord,
Throw some lights.
may I read this letter? My lord? We are pleased to inform you that on successful completion of your training,
Date.
date, my lord, at the top left hand side, just after reference.
Exhibit.
My lord, this is confirmation letter exhibit 4.
Exhibit 4.
Yes.
This is of 2010.
Yes.
And this payslip is of 2012. So there must have been some increase in sale. Yes. Future prospect has not been granted. Multiplier is, what is the
Multiplier, I don't have any mathematics.
multiplier 17, no problem.
No problem. He was aged about 28 years.
Only the question is, what would be the salary? Salary for the purpose of calculating the cost. It will be around about 15,000. I am not adding some of the like printing stationery, postage, courier, internet bandwidth, one-way speed force. So to balance the income tax aspect, I think it should be 50,000. Mr. Slack.
See, there are two parallel field force,
That I have deducted. I have not taken it.
5930 and 4620.
I have not taken it. I have not considered.
And twice basic salary and
Basic also I have. Yes. I have calculated basic salary 7883,
Yes.
HRA 2125,
Right.
conveyance 800, interim bonus 717, city compulsory allowance 1000, medical 700, LTA 400, plus contribution towards PF and ES. It comes to 15,054. I have not calculated this. I am not taking this.
But out of 27,000, these three components, 7883 basic salary, HRA and interim bonus 717, that should be given. Because twice it has been factored in.
I've just told you I have added basic salary 7883, HRA 2125, conveyance 800, interim bonus 717, city allowance 1000, medical 700, LTA 400 plus contribution towards PF and ESI. It comes to 15,054.
Less income tax.
Then I will add all these things, all the other allowances.
In out 15.
So I'm saying that if you balance this travel field force and everything, this internet bandwidth, everything, I have not considered that. So that will balance the income tax. So what you are suggesting, as per you, it will be 27,948. What will be the income tax on 27,948 if you can have it
On 27,928 not understand.
No, 27,948 less 2,562 less 768 and 514. 2,562 768 514.
Eliminated those.
Yes. You say income tax. This is, I think 15054 is the correct.
Secondly, just for the sake of community, his group has been given as per PM. When he is a medical representative, definitely he will at least
I think nothing is there. If nothing is there, what will this? What will the
that will not make sense.
on what basis?
That will not make
If there is no document, then tribunal has to assess the age. Can you say in absence of a document, if the court is assessing the age as per the postmortem report, it is bad assessment?
No,
Tell me.
It was my different contention.
Your contention is there should have been.
That is-
He's a matriculate. There should be a matriculation certificate. He should have brought it.
Because at least he will
So then will I consider his age to be 100 years?
No, that will not
Then you give the alternative.
yeah, not much
You
difference.
give the alternative.
128 years of age. It may be 1 or 2 years. That will be.
How does it matter if it is
Yes,
29?
that will not.
So if it is 29, it hardly matters. 26 to 30 is 17.
25 to 30 is the same rate.
26 to 30 is
Same
same factor. 17. Then how does it matter?
They will not.
15 is okay. Leave.
And Malon, no future prospect and Malon conventional rate only 15.
I've seen it.
Okay.
You heard Mr. SKMI counsel appearing on behalf of the applicants, David, and Mr. GC Cha appearing on behalf of the insurance company. I have also gone through the lawful recourse. The filing this appeal, the claimants are praying to enhance the amount of compensation awarded by the tribunal in MSC case number 161, so the tribunal according to you. Mr. Escala, in support of this appeal, submits that the deceased was a medical representative, and as per Exhibit 2, which is the salary slip of the month of June 2012, the salary of the deceased was 27,948. But the tribunal has considered the income of the deceased as 10208 for the purpose of computing the compensation. It submits that there is no basis of the basis for such calculation is erroneous and beyond the law. It submits that as per the judgment of the Honorable Supreme Court in the case of Ganesh Influencer, the income would be the salary less the amount paid towards income tax. As per him, since there is a documentary evidence which is Exhibit 2 on record, the tribunal could not have assessed the income to be 10,208. He further submits that the claimants are entitled for compensation under the head future prospect indemnity, which has not been granted commonly, which has not been granted by the tribunal, while finally assessing the compensation. So lastly submits that under conventional head, only 15,100 has been awarded in place of 70,000 as directed by the Honorable Supreme Court in the case of permission. The aforesaid are the only ground addressed by the counsel for the Mr. G.C. Jha, learned counsel appearing on behalf of the insurance company, opposes the prayer of the applicant and submits that the tribunal has rightly assessed the monthly income of the deceased at rupees 10208. He submits that if annexure, if Exhibit 2 is seen carefully, it will be clear that for the month of June 2012, the entry under the head basic salary has been made twice. One as 2562, another as 7883. The further submit that the HRA has also been recorded twice. Once as 768 and another as 2123. He further submits that conveyance field post and travel field post has been recorded twice. He further submits that internet charges, postage, courier, stationery are normally by way of reimbursements. And that being so, the same cannot be added with the salary. He further submits that the court below has correctly considered the PF contribution made by the deceased and has not accepted the same, and has not considered the same while calculating. Next. Considering the nature of dispute, this appeal, which is for the purpose of enhancement of the compensation amount, and the nature and the ground, nature of the arguments and the ground stated during arguments. This court feels that it is not necessary to go in details about the manner of accidents, the dependency, the application of multiplier, and the pattern whether the insurance, the fact that the vehicle was, the offending vehicle was insured with the respondent, insurance. Oriental Insurance Company Limited is also admitted. It is also admitted that at the time of accident the vehicle was duly insured and there was no violation of the terms and conditions of the policy. That being so, the only issue which is to be decided in this appeal is what would be the quantum of compensation after quantum of compensation. Exhibit 2 is the payslip of the deceased for the month of June 2012. When I go through this payslip, I find that total earning of the deceased for that month was shown as 27,948, and deductions for the month was 1,429. The deductions were on account of PF contribution and ESI contribution. This contributions are part of the salary. And further, from the same document, I find that twice the basic salary was credited. And twice the HRA was credited. The interim bonus also there is two entry of interim bonus for the same. The tribunal thus was correct in considering the basic salary as 7883 and HRA as 2125 and interim bonus as 717. Over and above the aforesaid amount, the conveyance charges at 800, city compensatory allowance at 1000, medical allowance at 700 and LTA is 400 needs to be added. The PF contribution and ESI contribution also needs to be added. As the Honorable Supreme Court in the case of Ramesh Shetty have held that the salary means for the computation of income, the salary has to be considered, which means the gross salary less the income tax. There are some other allowances which need not be considered for this purpose, which will balance the income tax components. When thus considering the above, when I calculate the monthly income of the deceased, the same comes to rupees 15,000. How much? Mr. Black, I said 15,054.
Yes.
15,000. Thus, for the purpose of calculating compensation, computing the compensation, the monthly income of the deceased is taken to be 1505. Admittedly, the deceased was bachelor and died at the age of 28 years. The tribunal, while awarding compensation, has not considered his future prospects. In view of the judgment of the Honorable Supreme Court in the case of Ramesh Shetty, the petitioner is how what percent, Mr. Jha? Petitioner was below the age of 40 years. Thus, 50% enhancement is to be granted on their future prospect, as the petitioner's job was permanent in nature and was salaried. He was salaried. Next one. On account of under conviction, that I find that only 15,000 rupees has been awarded, which should be 70,000 in terms of the judgment of conviction. Thus, next part. Thus, considering all these aspects, the amount of compensation needs to be recalculated, which will be as follows: 150
054.
5054 into 12 into 17 goes to 30,71016 divided by 2. 15,35,508. 508. Two. 15,35,508.
I will calculate it.
15,35,508 plus 767,754. Total 23,03,262 plus 70 plus 70 equals to 23,73,262. Yes, Mr. Chair. 23,73,262. Check the number. Thus, the total amount of compensation comes to 23,73,262 rupees. This amount will carry an interest at the rate of 6% per annum.
From the date of declaration.
The tribunal has awarded 10,56,216. So thus the balance amount will be
minus 50,000. 10,56,216 minus 50,000.
balance amount will be 13,70,046. Full stop. This balance amount should be paid, 6, full stop. This balance amount will be paid after deducting any amount which has been paid to the petitioners, which will carry an interest at the rate of 6% from the date of the award. This balance amount will carry an interest from the date of the award, that is on 23/1/2017 till the same is paid.
So 50,000 already paid and system.
Less the amount already paid. This is this amount.
Interest.
Serial number 38, MN number 245 of 18, Mr. DC Ghosh. For appellant, Mr. Ramesh Kumar, Mr. B.K.
Mr.
Chakravarti.
Chair, have you satisfied the award? Have you paid 10 lakhs?
Yes, my lord.
That amount is fixed. Yes, Mr. Ghosh.
My lord, we remember on the last occasion,
What is this? Yes.
my lord, on the last date, one lady advocate was appearing on behalf of the claimant. Whether my lord will here.
My junior was appearing on that date. And Lordship has asked me to pronounce a T, 5.8. On the basis of that, Lordship, it can be calculated. 4,25,000 it is immediately as per the pronouncity case.
Huge.
Huge amount. So I have to be.
Let us see monthly income of the district.
Monthly income is 3,000, Lordship. Only thing has not been.
Tell me what would be the adjustment. I'll leave it to you.
7,15,000 something. It is
120.
it is coming around
with the future prospect.
40% plus 40% minus 1 plus
It will be how much?
plus 70,000.
Yes, it will be
7
as per
lakhs.
7 lakhs.
7 lakhs.
Over here it has been 8 lakh 85. How much we have paid?
Instruction
7 lakhs. I have deposited 7 lakhs.
By the order of this court.
We have taken 7 lakhs. How much it comes to? As per your calculation, give me the correct figure.
7 lakhs 15,400 or like that.
7 lakh 15. 7 lakh 16.
16,000 or 20,000.
7 lakh 16,000.
Yes.
So as per my calculation, it was 7 lakh 15,120.
Yes.
So 60,000. He has paid 7 lakhs. Interest on 7 lakhs we have paid.
No, lump sum. I have just deposited and paid 7 lakhs by order of this court.
Are you happy with that 7 lakhs plus interest?
And 70,000 lordship that as per the Manassetti case.
Yes, sir.
Yes, that I have added.
We added.
Lordship.
After adding everything,
Everything.
Mr. Ghosh has calculated 7 lakh 16,000.
Lordship.
The court has granted you 8 lakhs. 7 lakh 35,000. 7 lakh 16,000 plus interest. What is the
9% awarded by the court below. No, whatever. Yes.
From the date of application, it
yes, it has to be. 9% is on the much higher side. 8%?
8.5%.
8%. Are you agreeable for 8%? Are you agreeable for 8%?
I'm always agree.
You seek instructions. It is 7,16,000 plus 8% from the date of filing of the claim. You agree it's well and good, otherwise the judgment will be 7,16,000 plus 9%. You'll be saving some.
At least 1%.
Or even, I don't know, if the next day if you don't agree, I may say that the difference is only 1 lakh, I don't want to intervene. Next week?
Yes, yes.
If you say that you may, I will just now start dictating.
ज़्यादा तो डिफरेंस होगा नहीं. डेथ केस है जो ऑर्डर कर दिया जाएगा. Whatever मेलर 9%, 8% जो क्या है इसमें? एक आदमी मर गया.
Heard the counsel for Mr. Devesh was appearing on behalf of the insurance company and Mr. Who was the counsel who was assisting you? Yes, where is she?
That is why she was appearing and she was well versed.
Heard Mr. D. K. Chakravarti appearing on behalf of the claimants. This is an appeal by the insurance company challenging the award passed by Central Insurance. So, by which an amount of rupees 8,85,800 has been awarded. It's compensation. Next slide. What are your grounds?
That is the standard
The
page 11 or
Mr.
7.
Devesh was appearing on behalf of the appellate service that the quantum is on the much higher side and is not according with the judgment passed by the Honorable Supreme Court in the case of Pranay Shetty and others. He submits that the Honorable Supreme Court in the Pranay Shetty in paragraph 56.59 59.8 has held that on conventional head, claimants are entitled to rupees 70,000. And whereas in this case, the tribunal has awarded 4 lakh,
425.
4 lakh,
Paragraph 41.
25,000 under the conventional head. He submits that this amount is exorbitant. He submits that the interest rate also is on the higher side, which is 9%. What is the date of death?
Date of death 16/9/12.
12.
G. 12 of
This are the only two grounds taken by the insurance companies. Mr. D.K. Chakravarti submitted that the tribunal has exercised its jurisdiction wisely and has granted 4,25,000 as compensation on conventional head,
Right.
which did not be interfered with. He submits that he further submits that the interest rate at the rate of 9% cannot be recognized. After hearing the parties and after going through the records, which are after hearing the counsel of the parties, this court feels that this case can be disposed of at this stage itself, without calling for the lower court records, in view of the admitted dispute between the parties and the judgment, and relying upon the judgment of the Honorable Supreme Court in the case of Commission. Next. The factor of accident, the nature of the accident taking place, the fact that the vehicle was duly insured with the ambulance, the age of the deceased, the income, etc. has not been disputed. Thus, I am not entering into those aspects which is already which is not disputed in this. The only dispute which needs to be addressed is the, as per the applicant, is the compensation under conventional head and the rate of interest.
Yes.
When I go to the award, I find that under conventional head, the tribunal has awarded 4,25,000 as compensation. This amount is really exorbitant. In terms of paragraph 59.6 of the judgment of the Honorable Supreme Court in the case of 59.8, the case of Pranay Shetty, the claimants are entitled to receive 70,000 very compensation under convention. Thus, in this case, also the claimants are entitled to receive compensation at the rate of rupees 70,000 under conventional head and not 4,25,000. So thus the amount of there is an excess amount of work.
अलग 40% ट्राइब्यूनल लेके उसको क्या
That's an excess amount of 3,55,000 has been provided. What which the claimants are not entitled to. So far as interest is concerned, the tribunal has awarded 9% interest. Have you paid the amount, any amount?
7 lakhs.
When?
That is giving
What shall this course on?
May to
Courts.
yes.
By the order of this
The
court.
claimant, the insurance company have not paid a single farthing to the deceased till
15/5.
16 May 2019.
Yes.
Considering this legislation is a beneficial legislation, the insurance company should have paid the amount of compensation, at least the amount which the insurance company themselves admits to the claimants. They failed to do so. Whether this amount was paid to the deceased at the time of, immediately after the death, which is in the 2012, and the amount was kept in fixed deposit, it would surely have earned 9% interest. Thus, this court holds that the awarding of 9% interest from the date of filing of the claim application cannot be found. No fault can be found with this. Thus, the amount of compensation will carry an interest from the date of filing of the claim application till 7 lakh rupees was deposited by the claimants, insurance company, by virtue of order dated 16 May 2019 past in this case. Next. The court, it is the duty of the court to see whether the compensation is just. The counsel appearing on behalf of the appellant, insurance company, heavily relied upon judgment of Pranay in support of his case, that in support of his case and to convince this court that the tribunal has awarded excessive amount of compensation under convention. The court has accepted the same argument. When this court has accepted the same argument and has relied upon the judgment of Pranay, I feel that the other aspects which have been dealt with by the Honorable Supreme Court in the Pranay, which is in favor of the claimant deceased, has also to be considered. While considering the same judgment and the judgment of Pranay and the impugned judgment, I find that the concept of future prospects which a deceased has not been applied in this case by the tribunal. Thus, this court feels that the claimants are entitled for compensation under their future prospect. Admittedly, the deceased was self-employed and aged about
32 years.
70 years and he is in 32 years. You have not read the file. Send your assisting counsel.
He left the courthouse.
Mr. Chakravarti, tell me, what is the age of the deceased?
But color.
Mr. Ghosh is smiling. Years. Deceased was 32 years. Come to page 6, paragraph number 9, fourth last line. 32 years. Thus, he was below the age of 40 years. He is entitled for enhanced he is entitled for 40% enhancement of the compensation amount. Considering this approach, what has been held above, the